Council Freedom of Expression Court is now in session. Honorable Judges Phillips, Cavalier, Danbury are presiding with Judge O'Regan as the President of the Court.
The current matter before this court is the case between Songa Yara and Azulfish as the applicants against the Republic of Porto as the respondents. Each side would have 45 minutes to present their case. With that, the first counsel for the applicants is requested to come forward. Judges, this is the timer. Can the respondent use it to keep their time?
Morning, Counsel. Please proceed when you're ready.
Thank you. Madam President, Your Excellencies, may it please the Court. My name is Kaylin Kok, and together with my co-counsel, Ms. Lee Jie-Ting, and my off-counsel, Ms. Teo Jie-Xuan, we appear on behalf of the applicants, Yara and Azulfish. I will speak for 21 minutes on the sanctions imposed on Yara, while my co-counsel, Ms. Lee, will speak for a further 21 minutes on the sanctions imposed on Azulfish. And we respectfully reserve 3 minutes for rebuttal. Your Excellencies, we are here today because of 3 posts Yara made on her Azulfish platform. She shared a video which appeared to show that Djibouti, the president's son, had attacked a police officer. This was amidst the Greenies movement which resisted the repeal of the Great Green Laws. The state of Porto saw fit to impose criminal sanctions on Yara, a prison sentence and a $50,000 USD fine, all because Yara could not show that these videos were not fake videos. Your Excellencies, these sanctions were a violation of her freedom of expression under Article 19 of the ICCPR, and we make 3 arguments in support. First, that the sanctions imposed are not provided for by law. Second, that they are not necessary. And last, that they are disproportionate. I turn first to my arguments on provision by law.
Counsel, you're not taking...
Are you taking the legitimate aim argument, or are you not?
No, Judge Danbury, we are not.
Conceding that both in terms of its drafting and its application, that the interference with your client's right to freedom of expression was pursuant to a legitimate aim?
Yes.
Thank you.
Thank you, Your Excellencies. I turn first to my arguments on provision by law. Your Excellencies, for a prosecution to be provided for by law, the law in question must be drafted with sufficient precision for individuals to reasonably foresee the consequences of their actions. This finds support in the 2021 African Committee of Human and People's Rights decision of Agnes and Rwanda at paragraphs 167, as well as the 2020 Inter-American Court of Human Rights decision of Borana and Chile at paragraph 13. Your Excellencies, the purpose of the provision by law limb is to guard against unfettered discretion and arbitrary exercise of power by the authorities. In the present case before us, there are at least 3 points of ambiguity in the state's actions and the domestic law, which makes it impossible for someone in the shoes of Yara to answer the following questions. First, Your Excellencies, what exactly was Yara charged with? We do not know. Based on the facts, all we know is that Yara was given a blanket conviction under Section 3 of the Digital Safety Law. But Your Excellencies will see at paragraph 14 of the facts that Section 3 has 3 distinct limbs of illegal content. First, a call for violence. Second, an indirect call for violence which can lead to physical or psychological harm. Third, speech that misrepresents the truth or are posted with reckless disregard for the truth. We do not know which limb Yara has violated.
But Counsel, could we go and look at each of the posts against the wording in Section 3 and see where that takes us? Could you take us through that?
Judge Phillips, indeed, we will be going through the wording of the post.
Would you like to do it now?
Certainly, Your Excellencies. For the wording of the post, we submit that these were not calls to violence and they did not infringe on Djibouti's right to
So
privacy.
let's look at each post.
Yes.
Yeah.
Your Excellencies, Yara's first post can be found at paragraph 26 of the facts, where she states, "We did not attack anyone. It was a peaceful protest. And if any violence occurred, it was in self-defense." Now, the respondents have argued that this post was a justification of violence. But, Your Excellencies, this post was just a recognition of the principle of self-defense. It was not an encouragement or a call for violence. She was distancing the protesters from any sort of violent measures being used.
And do we know whether the police were beating the greenies?
Judge Phillips, all we know is that the police were armed with batons and tear gas, and the protesters were unarmed. Now, although we do not know exactly whether the police were beating the greenies, we say that Yara had a sufficient factual basis to have made the statements that they were beating the greenies, based on the objective fact that the protesters had always been unarmed throughout the greenies movement.
But would you concede, for example, that in section 3BC, speech or videos that misrepresent the truth about the perpetrators of violence could possibly catch that first post?
Judge Phillips, under the provision by Law Lim, what we are concerned with is that the provision has not been drafted with sufficient precision, not so much of whether the law can capture her actions. Now, for the limb of 3BC, speech that misrepresents the truth, it is unclear, because what does misrepresent the truth actually mean? Is it an intentional dissemination of false information, or the innocent dissemination of false information is also captured?
Counsel,
We do not know.
there is authority, isn't there, that ambiguities of this sort in the drafting of the statute can be remedied by subsequent judicial interpretation. Isn't misrepresent the truth exactly that sort of open-textured drafting that a subsequent judicial decision can resolve, and therefore it's not facially flawed?
Judge Danbury, indeed, the wording of the law can be circumscribed using judicial decisions. But the Human Rights Committee, in its General Comment 34, has made clear that the burden is on the state to adduce such judicial evidence. And because they have failed to do so before this court, we must find that the provision by Law Lim has been violated.
Well, up to a point. I mean, it has actually, as we know from the facts, this statute has been assessed by the Supreme Court about its compliance with Article 10 and Article 19 through the through the countries having signed up to the ICCPR. So it has been through, there is evidence that it has been through judicial assessment.
Judge Danbury, but that is the role of this court. Just because it has been through the Constitutional Court within the Republic of Bodo does not preclude this court from assessing whether the state's actions and the domestic law were in violation of the Article 19 principles.
No, absolutely, but just to take you back to my point, you were asserting it's facially flawed. The phrase we were looking at is misrepresent the truth.
Yes.
And I'm saying there is evidence that there is authority that subsequent judicial assessment can deal with that sort of mischief. You said they haven't adduced any evidence, and I said, yes, they have. It's on paragraph 15 and 16.
Judge Danbury, allow me to clarify. The evidence that the state must adduce is that in the prosecution of Yara, the assessment of misrepresent the truth or other broad phrases like psychological harm have been circumscribed by the court, such that the authorities did not exercise unfettered discretion. But because they did not adduce such evidence, they have violated the provision by Law Lim.
It's slightly different, isn't it? Because on broad brush terms, there is evidence that the court has suggested it. But on the specific facts of this case, there isn't. So we're slightly at a loss. So how do we deal with that situation where there actually is evidence that it has been considered and therefore the mischief may well have been resolved?
Your Excellencies, it is our position that just because the state can adduce evidence to show that there was no arbitrary application of the law, the broad wording by itself violates the provision by Law Lim because it gives rise to the potential for unfettered discretion. But even if Your Excellencies are not with us on the provision by Law Lim, our case does not fail because the burden is on the state to show that they have not violated any of the three limbs under Article 19. And with that, I turn to my second submission on necessity. Your Excellencies, the respondents have argued from paragraphs 12 to 17 of their written submissions that it was necessary to prosecute Yara on two grounds. First, the protection of public order, and second, the protection of Djibouti's right to privacy and reputation. I address first the ground of Djibouti's right to privacy and reputation. Your Excellencies, we do not seek to downplay the consequences that Djibouti faced, namely the online threats and the physical stalking. But this court must strike the right balance between, on one hand, protecting the public interest in Yara's speech, and on the other hand, protecting Djibouti's right to privacy and reputation. Here, the balance lies in favor of protecting the public interest in Yara's speech.
But Counsel, here we have a young man who has no high public profile, happens perhaps to his advantage and disadvantage to be the son of the president, who's effectively been hounded out of his home country and cannot return. And part of that is as a result of the scale of the followers that Yara had. How heavily should we weigh those consequences when people know that they have followers of 20 million and use their social media platform to identify faces of people and put them at that sort of risk? How heavily should we weigh that in the proportionality balance?
Madam President, we do understand that Yara has a high extent of dissemination. And this is also what the respondents have argued in their written submissions, coupled with the fact that because of this high extent of dissemination, Yara had greater journalistic duties, which she violated. However, Your Excellencies, what we propose to the court today is that before we ask questions of whether Yara had violated her journalistic duties or whether the extent of dissemination had increased the harm to Djibouti, the crucial question before this court is whether the videos were true or false. Because, Your Excellencies, if we could prove that the videos were true and that Djibouti was indeed the attacker, then the public interest in Yara's post would be so great that no reasonable person could argue that Yara or Azufish had violated any duties.
Well, Councillor, just picking up on Madam President's question, I mean, do you really think that that's right? Even if it was true and you knew it was true, and there's a whole area about that, that publishing something that means one person is put up on a pedestal for people to then attack, and although it didn't happen in this case, could have been physically hurt or even worse, is that justified in given the situation? In other words, does a journalist have the right to do that?
Judge Phillips, it is our position that journalists like Yara do have the right to do that. Because where the state has an abundance of resources, but they choose not to open criminal investigations into what had happened on the 1st of April, and whether Djibouti was indeed the attacker of the police officer, and instead blame the protesters for the violence that occurred. In such a situation, it is all the more important for speech like Yara to exist in the public sphere.
Can we just run that through the common sense test, if we can? So it's your argument, is it, that a journalist has the right to what appears to be recklessly publish information which leads to someone having a threat to their livelihood? Journalists have that right?
No, Judge Danbury. Our submission is not that journalists can be reckless. Instead, it is precisely our point that Yara was not reckless because she had used the faces match facial recognition technology, which has a 99.9% accuracy rate, used by the government themselves and police.
Sorry to interrupt on this, but I think you're opening it slightly higher. There is ambiguity about the extent to which the material has been digitally altered, isn't there? Paragraph 40 of the fact. So opening it on the grounds that it was absolutely clearly not digitally altered is a bit risky, isn't it?
Judge Danbury, it is precisely our point that because even the experts from Faces Match and the experts hired by the public prosecutors could not determine or point to any conclusive evidence for whether the videos were digitally altered or not, It is because of this fact which we say that Yara has the right to allow her posts to remain in the public sphere. But even if, Your Excellencies, her posts were found to be completely false and that the videos were digitally altered.
Well, I think the issue is recklessness, isn't it, really? Her action. That's what we seem to be arguing about.
Judge Danbury, we would say that Yara was still not reckless, because under international law, the duty of journalists is to make factual statements with sufficient factual basis. And she had relied on a government technology with a 99.9% accuracy rate, and she did not make statements that directed any violence towards Djibouti or caused any public order threats.
Well, we'll get to post C in a minute, but what do you say about the fact that she clearly didn't know whether it was accurate or not? And when she was told by that Faces Match had worried about it, she left the post up. She continued to leave the post up, even when there was doubt about whether, in fact, it was accurate.
Madam President, it is our position that Yara was entitled to do so, because the freedom of expression extends to protect speech that is even false, because the whole purpose of the freedom of expression is to allow people to debate and for the truth to eventually come to light. Therefore, by leaving the post up, Your Excellencies, Yara did not violate any journalistic duties.
Well,
Councillor,
sorry, you
no,
go.
so I'm just, Councillor, thank you for this. I'm just perhaps a little troubled with the internal consistency of your argument. You told us before that a key issue for this court to consider and to establish is whether the video is true or not, because if it is, then it's definitely public interest.
Yes.
Then you also told us that it doesn't really matter, because even when in doubt, we still have in doubt whether the video is true or not, we have
Yes.
to consider it's in the public interest. And then now you tell us that freedom of expression even protects false speech
Yes.
and inaccurate information. Where does it stop? What is it, in your view, that journalists cannot do? At what point do we say this is too much?
Judge Cavalier, in the 2025 European Court of Human Rights decision of TOF and Romania, it makes clear that journalists cannot make statements with the sole intent to insult. And where their statements do not have a sufficient factual basis, they have violated their journalistic duties.
So deliberate insult is where to draw the line.
Yes, and also where the speech incites violence. It is
Shall
our
we move
position.
on to post C then? It might be interesting to hear your submissions on post C.
Yes, Madam President. Indeed, the respondents have pointed to post C as the clearest indication of a call to violence. But, Your Excellencies, the phrase, "Are we going to accept this or are we going to act? Our rights are in our hands," were not a call to violence. This is an appeal for civic engagement, which can take multiple peaceful forms, such as continued peaceful protests or legal challenges, none of which are incitement. Your Excellencies, this concludes my arguments for the necessity limb, as I have attempted to show that Yara's post did not threaten public order.
Can I just push you for a moment on post
Yes.
C? So this has taken place in an afternoon where there have been 10,000 people on the streets.
Yes.
A dozen people hospitalized as a result of what's going on.
Yes.
A highly volatile environment. And then to say, what are we going to do about this, doesn't seem to me to say necessarily that it doesn't say we should be calm, we need to let the police action take its course, but obviously that's not the tone of the post. It does seem, it's got to be understood in terms of its context. And what's your submissions on that context, which have already resulted in harm to kind of human beings?
Madam President is absolutely right that her post needs to be read in context. And in fact, this context goes back to the history of the Greenies movement, which is one that has always been peaceful, and the protesters had always showed restraint. At paragraphs 21 and 23 of the facts, Your Excellencies will see that the protesters never once took any violent actions towards the authorities. And although, like Madam President had pointed out, there was a clash that occurred on the 1st of April, what is crucial is that we do not know how these clashes had started. Again, all we know is that the police were armed with batons and tear gas, and the protesters were unarmed. The violence that occurred could have been a result of the state's authorities' own actions, and it does not lie in the mouth of the respondent to now argue that speech about the protests and speech trying to find out what had happened on the 1st of April should be restricted when it could have been their state authorities' own actions.
But we do have people who broke into Parliament. We do know that people were injured. And in fact, I think you're overstating the case on the facts as to whether or not protesters initiated the violence. I think the facts are we just don't know at this stage. And so Yara wouldn't have known either. In which case, again, just your submission on the context of what seems to be a call to arms at the very least.
Madam President, we understand that there was a group of protesters that had entered the Parliament. But what is also crucial for this court to consider is that there was a low likelihood of violence because Yara's post has been up for a year. But there has been no escalation of unrest or tensions or violence. And evidence following the publication can serve as strongly pointing towards a low likelihood of violence. Your Excellencies, this concludes my arguments for necessity. For the argument of proportionality, the state imposed a 50,000 USD fine coupled with a 3-month suspended prison sentence.
Counsel, you've got 1 minute left. So
Yes.
we've got a suspended prison sentence and $50,000.
Yes.
Which one is the most troubling from the point of view of proportionality for you?
The suspended prison sentence.
Tell us why.
Because, Your Excellencies, the suspended prison sentence created a constant chilling effect hanging over Yara's head.
Have you got any authority to back that up?
Yes.
Tell us
In
what
the
it is.
2022 European Court of Human Rights decision of Roulin and France, it stated that suspended prison sentences create a chilling effect because individuals like Yara would be constantly afraid of being thrown into prison if they speak on political issues or matters of high public interest.
Do you recall what the speech at issue it was in that case?
Yes, Mr. President. It was about a journalist that had incited violence and had stated that the terrorists in the terrorist attacks in Paris were brave and that they had fought bravely. And accordingly, this was held to be terrorism.
So I know your time's up, but
Yes.
just to finish the point, just to clarify what are you saying, the speech in that case was glorification of terrorism,
Yes.
it wasn't incitement to terrorism,
Yes.
is that correct?
Yes.
So we've got an incitement case here rather than glorification,
Yeah.
so is the authority on point?
Judge Danbury, in fact, it is our position that that authority supports our point because for glorification of terrorism, it is a more severe form of expression or speech than just a mere innocuous call to stand up for their rights. But even in that scenario, the court held that a suspended prison sentence for the applicant was disproportionate. Here, it was a matter of a high public interest. And the state should not have...
Just on that, it doesn't seem to me that it's correct to say that glorification is a more damaging or worrying form of speech than incitement to imminent harm. I mean, incitement to imminent harm by its very definition is asking people to go out and commit harm right now. And so if you flip that and you accept that, in fact, glorification is a less serious form of speech, how does that affect your argument on the relevance of the authority?
Madam President, then we would rely on other authorities to show that suspended prison sentences are not proportionate. In the 2015 European Court of Human Rights decision of Mbala in France, the 2017 decision of Belkacem and Belgium, as well as the 2022 decision of Bonnet and France, in all of these cases, the applicants had incited hatred, which is more severe, Your Excellencies, under international law than just justification of terrorism and an innocuous call to action. But in these cases, the applicants were given a suspended prison sentence, and the court held that this was disproportionate because it created a chilling effect. Your Excellencies, our position is that the sanctions imposed on Yara were disproportionate and a punitive overreach, and accordingly violated her Article 19 rights to freedom of expression.
Thank you,
Your
Counsel.
Excellencies, this concludes the arguments for the first applicant. I now hand the time over to the second applicant to address Azu Fisher's right to freedom of expression. Thank you.
Thank you, Counsel. Counsel, please commence when you're ready.
Madam President, Your Excellencies, may it please this court. As earlier introduced, My name is Lee Jie-ting, and I continue the case for the applicants. I will address this court for 21 minutes on the issue of the sanctions imposed on Azul Fish. Your Excellencies, the state's interference with the right to freedom of expression does not just stop at Yara. Rather, it extends to the social media platform upon which her post had been made. Azul Fish did what any social media platform would have done to promote and protect the right to freedom of expression, a fundamental human right. And yet,
Councillor, can I just ask, is Azul Fish just protecting other people's rights, or is it maintaining that it has its own rights?
it is maintaining that it has its own rights as well, and this stems from its ability to impart third-party expressions. Now, this is a right that is protected under Article 19(2) of the ICCPR as well. And here, just for 3 posts published by Yara on the 1st of April, where she sought to discover the truth around the perpetrators of violence during these gatherings, Azul Fish now faces the unprecedented sanction of a permanent prohibition unless it becomes independent of its parent company.
Is that really why it's facing the prohibition, or is it because of its intransigent attitude to the application of court orders?
Well, we would argue that it is because of Yara's post that it is first facing the sanctions that the criminal court has imposed. But as to the Supreme Court's decision, we would say that this was because of its criticism of the court. And this is also the position taken by the respondents in their written submissions, where they have argued that it is because Azul Fish has an allegedly unrepentant attitude that the court has increased the sanctions. And we would say that this was not a proportionate thing to be done by the court, which we would address under our submission on proportionality.
So are you saying that the statements that Azul Fish made, criticising the court and indeed disobeying the court order, those are its freedom of expression? Is that a separate issue to sort of what it did with Yara's posts?
Well, we would say yes, it is a separate issue. And in any case, the right to freedom of expression recognizes that even courts are not immune from scrutiny and criticism. This is to protect the democracy of the respondent state. And this has been recognized in the 2005 European Court of Human Rights decision of Skalka and Poland at paragraph 43. Now, we recognize that perhaps Azul Fish could have worded its post better, but this is still something that is protected. And therefore, in light of the fact that Azul Fish was simply trying to promote the right to freedom of expression in its state, in the respondent state, the sanctions that have been imposed by the respondent states are unjustified and violated its right to freedom of expression.
Councillor, can we just test that briefly? You said it simply was trying to promote freedom of expression. We know that from paragraph 43 that Azul Fish makes $25 million in less than 5 minutes. Is there not, do we think, possibly a financial interest in this?
Well, this 25 million in 5 minutes we submit is simply an exaggeration by Azul Fish and cannot be taken as an accurate account of its earning capabilities.
Well, let's put a pin in that for the minute, but go back to the question. You were asserting that, in effect, Azul Fish's position was as a free speech warrior, and I'm suggesting there may be a commercial interest in its stance as well.
Now, we do not seek to deny that there is also a commercial interest in the posting and promoting of Yara's post. And this
may I just follow that up with one question then? So if there is a commercial interest in this, is it the case that, and it seems to be possibly arguably on the facts, that Azul Fish is content to defy courts when it might make money from it?
Well, our submission does not go to the extent to say that it is willing to deny court orders. And our issue
sorry to interrupt again, last time I'll interrupt. Paragraph 39, Azul Fish refused to comply with the order, and that's the first court order.
Now, in relation to this interim injunction found at paragraph 39 of the facts, it relates to our subsequent submission on necessity. And we say that this interim injunction does not satisfy the requirement of being sufficient notice to Azul Fish to remove Yara's post. And that is why it has not complied with this court order.
Can I explain where I'm coming from here? So at least in the European Convention on Human Rights, there are different gradations of speech, some of which is more protected than others. And political speech is protected at a high level and commercial speech is at a low level. I'm trying to work out and test whether this actually is a pure political speech or whether there's a commercial speech element to this.
Well, we would say that regardless of whether it is commercial speech or political speech, what is required from the state here is sufficient notice before Azulfish is required to comply, given that this requires Azulfish to infringe on the right to freedom of expression of its users. Now, Azulfish is just an intermediary. It's not in any position to be a state police when it has not been provided sufficient notice by the state. Now, this relates to our submission on necessity.
Sorry, Counsel, sorry to interrupt, but when you say Azulfish is only an intermediary, how does it play out against you saying that it imparts information, it's entitled to freedom of expression, and the criticized courts, which is entitled to? Is it an intermediary? Does it impart information? Does it hold opinions about the legitimacy of court orders? Where do you stand on that?
Well, an intermediary has been defined under international law as being a service provider that helps transmit content from third parties.
Sorry, Counsel, what is the international law that defines intermediaries?
This has been defined in the 2011 Human Rights Council Special Rapporteur Report by Frank LaRue at paragraph 38, as well as by the Council of Europe. And they have stated that intermediaries include online communication platforms such as Azulfish, a social media platform. Therefore, it is a platform that has the right to freedom of expression as well, and it should be protected as such. Now,
But
here,
if it's got its own free speech rights, then as your co-counsel said with regard to Yara, surely it also has responsibilities in that scenario. It can't take all those rights and have no responsibilities. So in this case, it gets told by a court to take something down and it ignores it. Where is its, what checking did it do in terms of the rights and wrongs?
Judge Phillips, we recognize that intermediaries do have responsibilities, but international law is clear that only under two circumstances must intermediaries remove content. First is if this content satisfies the clear unlawfulness standard, and second, if state authorities have provided sufficient notice about illegal content. And I will expand on this subsequently in my submission on necessity.
But I mean, just picking up on that, as I understand it, in terms of the second point that you made, it's the company that provided the technology that makes the application to the court. And they, first of all, asked your clients to take the material down. And then when that didn't work, they went to the court. How can that possibly not constitute adequate notice?
Well, that is because adequate notice must come from state authorities only. And therefore, while the respondents may have alleged in their written submissions that there are multiple notices made to Azulfish, only this interim injunction could have potentially been noticed. Now, we recognize that...
And sorry, just on that, is there authority for the fact that notice can only come from the state?
Yes, this has been recognized in Principle 39.4 of the 2019 African Commission of Human and People's Rights Declaration of Principles on Freedom of Expression.
Because in the UK, for example, on the Defamation Act takedown requirements, it can be the complainant who can serve a notice, and that is deemed to be adequate.
Well, that may be the case, but international law, such as in the African Declaration of Principles, has stated that only state authorities can give notice. And this is because only state authorities are best placed to balance the competing interests that are involved here, that being Azulfish's as an intermediary's right to freedom of expression, the right to freedom of expression of its users, as well as the rights and reputations of other users affected by these posts.
Sorry, Counsel, on this, because you're, of course, presenting this court with an interesting principle from one region. You know this court is bound by precedent and authorities from different international and regional systems. Can you advise this court on whether the precedent and the principle you're presenting to this court is somehow generally and universally applied at a comparative level, or if there are different takes and perspective on this?
Now, in relation to this African Declaration, it has been recognized that Article 9 of the African Charter on Human and People's Rights is effectively similar to Article 19 of the ICCPR, and this has been recognized in a 2022 forward by the Special Rapporteur, Topsy Sono. Additionally, this principle about takedown notices needing to be clear, unambiguous, justifying why the illegal content is illegal with reference to domestic law, as well as coming from state authorities, has also been recognized in Article 9 of the European Union Digital Services Act. And therefore, we say that these authorities should be persuasive before this court. Now today, I make 3 submissions before this court as to why Azufish's right to freedom of expression has been violated.
Sorry, counsel, one more on this. Can we just run this proposal through the common sense test? So as far as I understand it, you're saying that any takedown request has to come from a state entity. If you can imagine for a moment that Twitter makes a harmful statement about me and I want it to come down, that means that I have to complain to the police authorities have to investigate it, and then they have to send an official notice through to the kind of the platform to take it down. Can you see the huge administrative burden that's going to place on me? It doesn't seem to be merited.
Judge Danbury, we understand this concern, and therefore it is not only under these 2 circumstances. If a private individual like yourself wishes for Azufish to remove the post, then it can also submit a request through the platform's official takedown and notice system. Now, it is here that Azufish also has this system in place, and it can be seen from paragraph 10 of the clarifications. But on the facts, there has been no submission through its request system, and therefore it is only under those 2 circumstances should Azufish remove Yara's post.
So only if it comes through their official system or if there's a state entity requesting it. Those are the only 2 circumstances.
So not even in this case where Faces Match has made the request, the company that supplies the underlying equipment?
Yes, we say that in this case, it also does not satisfy this requirement given the uncertainties surrounding all of this Faces Match technology and the identification of which of Yara's posts was illegal.
If we agree and expound this as a principle, it does seem to create a rather curious administrative system that an official takedown request is the only way, or through an accompanist mechanism is the only way to put a company on notice. It seems vastly overly bureaucratic, doesn't it?
Well, Judge Danbury, we would disagree there. This takedown notice system is available to any private individual who wishes to submit a complaint. So that is one channel that it can utilize. And separately, if state authorities determine that there is illegal content, it is incumbent on them, as the protectors of the right to freedom of expression, to provide notice to platforms. Now I make 3
Sorry, Councillor, you may have said it already, but I have to admit I'm slightly lost, so apologies if I ask you to repeat something. But in light of this, why do you submit that the interim order that was rendered by Boto's court would not comply with your, would not constitute adequate notice for the platform?
Now this relates to my submission on necessity. This requirement is not satisfied given that the interim injunction here is not clear, unambiguous, and does not justify why Yara's post should be removed.
No, I'm just asking why. So you're saying a platform needs to receive notice from a state entity in order to remove content. In this case, a platform, your client, refused to comply with a court order. Why is it not sufficient notice from a state entity?
Judge Cavalier, we submit that this interim injunction is not sufficient notice, and that's why no obligation is imposed on Azufish.
Yeah, but my question is why?
Now, we say that for 4 reasons. First, this interim injunction relates to Post C. Now, in Post C, it contains a screenshot of the Faces Match application matching Djibouti as the attacker in the videos. This faceless match technology has a 99.9% accuracy, and this is even by its own claim found at paragraph 35 of the facts.
But what has this got to do with adequate notice? You're saying there are 4 reasons why this is not adequate notice, the interim injunction. I can't understand why this submission has anything to do with adequate notice.
Well, this is because we are saying that Azulfish and Yara had relied on this faceless match technology and the fact that it had a 99.9% accuracy.
But at this stage, the manufacturer of the technology has first written to Azulfish to say it's not reliable, no response. Secondly, it's taken the effort to go to court and say this is not reliable technology. We don't know the full detail, but they're saying it's not reliable. There's an interim order, which normally would be followed by a full hearing by the court in which Azulfish can put forward whatever case it wishes. An interim order given the potential risk to the broader community to say, take it down for the moment. Now, what I want to know is why that isn't adequate notice. Very much as my colleague does too.
Madam President, this relates to our second point on how there were uncertainties surrounding Yara's post and its illegality. Initially, Faceless Match had alleged that it was post C that had been generated by AI and constituted fake news. The interim injunction was granted on a similar basis of post C being digitally fabricated and constituting disinformation. However, in subsequent investigations by Faceless Match's own engineers, they determined that it was not post C, but rather the videos contained in post B had been digitally altered. And this is compounded by the subsequent investigation by the public prosecutor's experts. They were divided and unclear as to whether these videos were even altered. And given all of this uncertainty surrounding which post exactly was altered.
Let's just go back to what my colleague Judge Danbury refers to as the common sense test. This is a post with somebody's face on it who is being alleged to have committed a crime, effectively, which there is now doubt as to whether it is in fact accurate or not. Can you really say that in those circumstances it's appropriate for the service provider to say we're going to leave it up because we don't want to comply with the interim order, regardless of the fact that there have been material doubts raised about one particular individual who's now been seen by 20 million people? Why is that not, how can you make an argument about adequate notice? Is that not exactly the right response for the court to make? Once they've had an argument and determined whether it's accurate or not, then they can make a final order and say it can go back up or it must stay down.
Madam President, we would say that here it was reasonable for Azulfish to not have complied with this notice given these uncertainties. Azulfish is not a state police. It was in no position, in light of these uncertainties, to have made the call to remove Yara's post. That was only a call that the state can make, and this has been recognized in the 2021 Human Rights Council Special Rapporteur report by Irene Khan at paragraph 58. And therefore, the sanctions here were not necessary.
But Councillor, sorry, I mean, I know we're going on about this, but it is an interesting area. And I mean, even if one were to say that one could understand why at the time the post was justified, and there are arguments on that, but even if one were to say at the time, surely these duties that we've talked about are continuing duties. And so things can change. So you get to a stage where there are doubts, and those doubts in some way or other should be reflected. And as the platform, the hoster that is providing the audience for this, that is the time to reflect, as my co-judges have said.
Judge Phillips, if there was really any real reason that Yara's posts were false, then the state must have provided a notice to Azulfish to that effect. Now, even if this court is not with me on this point of necessity and adequate notice, our position, we only need to prove one of the limbs under Article 19.3 in order to make up our case. The burden lies on the respondent state to prove all 3 limbs. And therefore, I will move on to my subsequent 2 submissions.
Counsel, you've got very limited time. Why don't you choose your strongest argument? Give us that one on the ones that remain.
Well, we would submit that the sanctions imposed on Azulfish are disproportionate.
Which ones? So we've got the fines, we've got the divestment orders, we've got the takedown orders. I suggest you pick your strongest one and give us that.
Well, our position is that all 3 sanctions of the permanent ban, fine of 25 million, and condition to divest are disproportionate. But I will address this court on the permanent ban. Now, permanent bans are incompatible with the ICCPR. This is because they extend the scope of interference beyond the illegal content, rendering even legitimate content inaccessible. And this has been recognized by the Human Rights Committee in its General Comment 34 at paragraph 42. This ban is made even more egregious by the fact that it has been imposed because Azulfish criticized the court,
Counsel,
as earlier
the
queried
ban,
by this.
I'm hustling you because you have 1 minute left. A permanent ban hasn't strictly been ordered. An unless order has been made. They haven't been banned. The ban hasn't happened. What's happened is that they've been told to do something, and if they don't do that, then there will be a ban.
We understand that this is an unless order, but regardless, all three sanctions are disproportionate. There is still the chance that this permanent ban would kick into effect.
The reason for arguing is you were citing the international authorities about the disproportionateness of permanent bans, and I'm pointing out we actually haven't had a permanent ban issued yet.
Judge Danbury, if I may just answer your question.
Yes, you may.
Well, in relation to this, even if the permanent ban has not been kicked into effect, the test under proportionality is for the least intrusive measure to be imposed. Now, the issue here is that this permanent ban, as earlier queried by Your Excellencies, was not even in relation to the state's legitimate aims. It was for the criticism of the court, and that, for that reason, the respondent state has imposed an entirely new criminal sanction, one even not contemplated within the law, and that cannot be the least intrusive measure taken by the state. Now, unless I may be of further assistance to this court, this concludes my submissions.
Thank you very much, Counsel. Morning, Counsel. Please commence when you're ready.
Your Excellencies, may it please the Honourable Court, good morning. My name is Kashish, Counsel on behalf of the Respondent, the Republic of Boto. With me is my co-counsel, Gauri, and of-counsel, Divisha. Over the course of the next 21 minutes, I will be addressing Issue A, followed by my co-counsel, who will be addressing Issue B for the next 21 minutes, respectfully reserving 3 minutes for Sir Rebuttal. Your Excellencies, false and offensive speech spreads at a rapid rate and converts social media into a conducive platform for the perpetuation of violence and the manipulation of human thought. In keeping with this, while mirroring the submissions of the applicant, I shall seek to satisfy this court that the restrictions imposed upon Yara are not violative of Article 19 of the ICCPR because they fulfill the three-part test, that is, they are provided by law, in pursuance of a legitimate aim, and necessary for a legitimate purpose.
Counsel, they've not advanced the legitimate aim argument.
Your Excellencies, however, it is the burden of the state to ensure that all three of these prongs are fulfilled in order to show that a violation of Article 19 of the ICCPR has not been fulfilled.
Well, you may want to choose where to address the fire when you've only got 20 minutes if the applicants haven't taken the legitimate aim argument.
Indeed, Your Excellencies, I will briefly show how the legitimate aims present in the case have been met as I proceed with proportionality. May I first begin with provision by law, Your Excellencies? In this regard, I will make two submissions. First, that the DSL is sufficiently precise and allows for foreseeability. And second, that the DSL allows for adequate procedural safeguards which provide against unfettered discretion. Proceeding first with precision and foreseeability, Your Excellencies. The opposing counsels claimed that Yara has not been informed of the particular subsection under which she has been convicted. However, Your Excellencies, at the very top of their submissions, the opposing counsels also conceded that Yara was convicted for failing to prove the truth of her videos. Your Excellencies, this only speaks to the fact that in the present case, the subsection under Section 3B that has been invoked is Section 3BC. The mere fact that the prosecution before the Boto Central Criminal Court was started on the basis of Faces Match's public statement, the very public statement which conclusively said that Yara's posts cannot be relied upon as an accurate account of the events that took place on 1st April was the basis for this prosecution, which shows that it is Section 3BC that has been invoked. Your Excellency is now coming to the facial challenge that was raised by the applicants on Section 3BC. No doubt, precision and falsity, foreseeability are essential to any law.
I'm sorry, counsel, to interrupt you. Just to make sure I'm understanding your argument correct, is it your submission that Section 3, letter C, was the basis for all the restrictions, all the sanctions imposed on Yara, and therefore it is a disinformation case we're faced with? The problem here is that Yara's posts misrepresented the truth or showed reckless disregard for the truth. This is the problem we are confronted with.
Yes, Your Excellencies. We will be addressing Section 3BC to show how her conviction falls under this subsection. Your Excellencies.
So we're just, again, we're not considering whether the speech might have been incitement to violence.
Indeed not, Your Excellencies. Today it is not our submission that Yara's posts were a call for violence. It is our submission that they were false.
Sorry, Counsel, I'm being dense. You'll have to bear with me. Run me through your argument again, why you think that we are absolutely sure that Section 3BC is the one that's engaged. I'm looking at the clarifications, clarification 15, where the specific question's asked and the answer comes back, there's no answer required. Tell us why we're convinced that it's C.
I acknowledge your concern, Your Excellencies, and to demonstrate this, may I bring you to page 11 of the competition case, particularly paragraph 41.
I've got it.
And if Your Excellencies are with me, I read the first line with the court. In light of the Faces Match's public statement, the statement, Your Excellencies, that showed that Yara's posts were false, the public prosecutor started proceedings against both Azulfish and Yara for violations of the digital safety law. This speaks to the fact, Your Excellencies, that it is Section 3BC that has been invoked.
How?
Your Excellencies, immediately above in paragraph 40, the content of Faces Match's public statement is available. And if I may read the second line of that paragraph on page 11 itself, they stated publicly that in their view, the videos could not be relied upon as an accurate account of factual events.
Counsel, the fact that the word violations is in the plural in paragraph 41, does it possibly suggest that we're faced with more violations, possibly to other categories than Section 3BC?
Your Excellencies, it is our submission that the plural here has been used only to speak to the fact that Azulfish was convicted under Section 11 of the DSL and Yara was convicted under Section 3BC of the DSL. The fact that the basis of the prosecution was the falsity of the posts shows that it is Section 3BC that has been invoked.
Quite a lot of work is being done in your interpretation of the words "in the light of" in that. You're smiling, which is fine, but it shows that perhaps there is still sufficient ambiguity on this for it to be a reasonable interpretation that the applicant doesn't actually know what she was convicted on. So we're in a position here where you are asking us to make a definitive judgment that the interference with her right does actually not breach the legality argument in a situation where there's ambiguity. What should we do?
Your Excellencies, to take 2 steps back. The clarification only says no answer required. It does not say that Yara was not supplied with the subsection under which she was convicted.
Absolutely.
Your Excellencies, we don't just stop at Faces Match's public statement. The series of paragraphs in chronology show that falsity was first pointed out by Faces Match by way of an official request. Falsity was pointed out by the judge of first instance in its interim order. Falsity was then pointed out by Faces Match in its public statement. The series of facts, Your Excellencies, speak to the fact that the post was false and that was the basis of the prosecution. There is nothing on the record, Your Excellencies, that points to the fact that this prosecution could have been under any of the other subsections.
So if you're pinning your colours to the mast of 3BC, what is your argument as to whether, in fact, Ms. Yara did publish in relation with reckless disregard for the truth, given that at that stage when she posted with the post C, which is what she was convicted of, her view was that 99.9% certainty this is an accurate photograph. How could that be reckless disregard for the truth?
Your Excellencies, the 99.9% accuracy that Faces Match provides for is absolutely valueless when we see that the videos input by Yara themselves were digitally altered.
But she may or may not have known that. We have no evidence that she did. When what we do know is what she did know and what she actually asserted was that the Faces Match is very reliable.
Indeed, Your Excellencies. Therefore, we suggest that there are two situations that could have occurred in Yara's case. The first situation is that Yara herself digitally altered the videos, in which case foreseeability is easily established. The second situation is where Yara received these digitally altered videos from a source, ran them through Faces Match, and posted the screenshot. Even in that case, Your Excellencies, to claim the journalistic privilege that the applicants have relied upon, Yara needs to undertake due diligence.
No, but the question she's got, or the question that you've got to answer is whether, in so doing, on option 2, as you've put it, that was could be considered reckless disregard.
Your Excellencies, to demonstrate how this was reckless disregard, allow me to set the standard for due diligence. The standard for due diligence comes from the case of Azadlid and Zaidov versus Azerbaijan that was decided by the European Court of Human Rights in 2022. In that case, the court held that providing the sources of one's verification, providing independent research to ascertain whether rumors were true or not, or even providing factual assertions before domestic courts is the most minimum level of fact-checking that a journalist is required to undertake. In the present case, Your Excellencies, Yara could have verified with eyewitnesses present at the protest.
Counsel, has the European Court ever considered the issue of standard of due diligence before 2022, which is 3 years ago? It never came up before.
My apologies, Your Excellencies. To clarify, your question is whether this standard has been previously established.
Yes, or to elaborate more on my question, sorry, why are you picking this specific authority? Is this the most authoritative precedent we have?
Your Excellencies, we pick this authority because it lays the standard of due diligence at the most minimum level of fact-checking. We recognize, Your Excellencies, that this is an exercise of balancing. Yara is an independent journalist, and therefore the requirement of due diligence placed on her cannot be the same as of a news portal or a journalist house. Therefore, Your Excellencies, we choose an authority that places the threshold of due diligence at the most minimum level of fact-checking.
But aren't there lots of authorities under the ECHR that talk about the duty being of good faith or reasonable care and actually allow for the fact that journalists may make errors on the truth?
Your Excellencies, while journalists may make error for truths, after they have been informed of the truth, at that point, Your Excellencies, it's not error, it's reckless disregard. And to demonstrate how, Your Excellencies, even after Yara was told that there was falsity, Yara did not do anything. If I can get your attention to page 11 of the competition case.
Just before you do that, it might be useful at this stage to put in a little distinction between the particular interferences that we're talking about, that are being claimed about. So we have an interference with speech in relation to the official first takedown order and subsequent things, subsequent takedown orders up. Just clarify which one you're talking about here at the moment, which interference of the speech you're talking about.
Your Excellencies, with respect to Yara, there has only been one interference, which is the Boto Central Criminal Court's order, which fined her and gave her a suspended prison sentence. All other takedowns, Your Excellencies, were directed at Azulfish, the provider on whose platform the posts were available.
And why were there not interferences with Yara's rights? It's Yara's posts that have been taken down. Why do you say it's an interference with Azulfish's rights?
Your Excellencies, it is our submission that this is in fact also an interference with Yara's rights. However, our submission here is to say that this interference satisfies the three-part test of Article 19.3 of the ICCPR, and therefore, Your Excellencies, was a justified interference. And Your Excellencies, to demonstrate Yara's reckless disregard, if I may get you to page 11 of the competition case. Your Excellencies, on paragraph 40, which moves on to the next page, right at the top of page 11, and I'm reading the last line with the quote, if Your Excellencies are with me. Despite that Your Excellencies, being Faces Match's public statement, clearly pointing out that these posts were in fact false, Yara neither deleted the posts nor made any public comments about the truthfulness of the videos. Your Excellencies, due diligence does not end at the time of posting. Journalists have a continuing obligation to undertake due diligence, and we get this from the Ethics of Journalism of the Council of Europe.
Just to counsel, so your argument is not that she was reckless when she posted them, but she was reckless when she didn't take them down when asked.
Indeed not, Your Excellencies.
So you concede that her actions were completely appropriate journalistically and not reckless, posting at 15:30, 16:30 and 18:30.
Your Excellencies, to take two steps back, our submission here is to say that Yara did not undertake due diligence either at the inception of the posts or even after the posts.
Okay, so this is where we come back to what the actions are and when the recklessness is. So you are maintaining she was reckless when she posted them in the first place, and then she was reckless again when she didn't take them down.
Your Excellencies, unfortunately, we do not have facts on the record which speak to any form of due diligence being undertaken. And in
Well,
that...
sorry to interrupt, but we do kind of. I mean, due diligence is context-specific and time-specific. News is a perishable commodity, as we know. There is a protest which is going on. She posts at 15:30, she posts at 16:30, she posts at 18:30. She does it by crowdsourcing a piece of information, by using, and this is to adopt the applicant's arguments, by using a piece of technology which the state recognises as useful. How can that not be demonstrating sufficient due diligence, and how can that be reckless?
Your Excellencies, to answer your question in two parts. First, in the absence of any facts which speak to positive due diligence or negative due diligence, we say that the scales tip in our favor when we look at Yara's post-publication conduct.
Sorry, one more time. The absence of facts, and I'm suggesting there are facts which show due diligence, and that's crowdsourcing it and sending it out to a piece of tech which the Boto police think is a good one.
Your Excellencies, it is our submission that faces matches 99.9% accuracy cannot be relied upon in this specific circumstance because the very videos input by Yara were digitally altered.
Did she know that?
Your Excellencies, it is our submission that she should have known that because she should have undertaken her due diligence.
Well, you said...
Counsel, can you indicate to this court what specific actions, as a matter of example, you believe a good journalist should have taken in the circumstances at the time of posting?
Indeed, Your Excellencies. Yara could have verified with eyewitnesses who were present at the protest. Yara could have verified her source who sent her these digitally altered videos. Yara could have even verified with the police who was present at the protest. Your Excellencies, there are facts to say that the police authorities present at the protest pointed out that it was in fact a greenie who infiltrated the violence as opposed to Djibouti. At the very
Is that feasible? So you suggest a journalist at the protest will go to a police officer and say, sorry, can you check this video for me? Is that realistic?
Your Excellencies, it is our submission that is feasible. We understand that Yara had very limited time to make these posts. However, this has to be seen in the wider context. At the time when Yara made these posts, the protest was completely over. Your Excellencies, at that time, the repeal of the Great Green Laws has already been suspended. If Yara had undertaken one more step of due diligence by going to the police authorities, verifying the content of the videos, getting a statement from Djibouti, Your Excellencies, that would have saved Djibouti, a private figure in this case, from all of the damage that was against him.
Counsel, let's put ourselves in her mind. According to what she knows, the police have been thumping greenies on the head. So it doesn't seem reasonable to expect her to go to a police officer and say, can we check this? She might be frightened about being thumped on her head.
Your Excellencies, even if Yara could not go to the police officers who were present at that specific point in time, Yara could have spoken to the police authorities generally. Additionally, Your Excellencies, Yara's due diligence does not need to stop at police authorities.
So just to extend this, so a journalist to be considered not to act recklessly needs to check all of their information with the police before they publish?
Indeed not, Your Excellencies. That is not our submission.
Sounds like prior restraint, doesn't it?
Your Excellencies, our submission is not to say that every single piece of evidence must be run against the police. Our submission here is to say that if Yara knew that the videos that came to her were from a source that cannot be relied upon conclusively, at that point, Your Excellencies, the very least that Yara could have done is gone to the police authorities. Additionally, Your Excellencies, even if Yara received these videos from a source and she wasn't fully certain about it themselves, Yara could have added a rider or a clarification to those posts that this cannot be fully relied upon and this has been received from an external source. Even that kind of clarification, Your Excellencies, attached to Yara's posts would have not resulted in any of the damage that resulted against Djibouti.
Councillor, I'm anxious about time. I wonder if you should not move on at this stage.
Indeed, Your Excellencies. Coming to my submissions with respect to the necessity in the present case, necessity is tested at the helm of the existence of a pressing social need and proportionality. A pressing social need, Your Excellencies, is tested basis the context, the content, the status of the actor involved, and the extent of the dissemination. In the present case, Your Excellencies, the context in which Yara posted was highly socio-politically volatile. The content, Your Excellencies, the opposing counsels contended that the investigation has never been started and the content has not been conclusively proven to be false. However, Your Excellencies, investigation was in fact started and Boto's Central Criminal Court and the Supreme Court of Boto have conclusively found this content to be false. In line with the case of Egle Cusete versus Lithuania, decided by the Human Rights Committee in 2016, Considerable weight must be given to a state party's determination, especially when evidence inquiries are involved, when manifest error or a denial of justice cannot be shown by
So,
the
Councillor,
applicants.
on the facts, where are the manifest errors that the court found?
Your Excellencies, to clarify, it is our submission that considerable weight should be given to a state party's determination unless the applicants can show manifest error or a denial of justice by way of state authorities. And it is our submission, Your Excellencies, that the applicants have failed to do so today. As for the status of the actor involved, Yara's following, Your Excellencies, alone accounts for nearly 30% of Azulfish's total user base. Post C alone was disseminated 10 million, was liked 10 million times and shared 3 million times.
But is post C, I don't quite understand how post C fits into 3BC. What is it in post C that might be said to breach that clause?
Your Excellencies, paragraph 32, if I may bring you to paragraph 32, and if I may read the first line, this post also contained a screenshot of the Faces Match app, which contained a 99.9% probability of the unknown face being Djibouti.
So it's the video, it's the face of the Djibouti that is the misrepresenting the truth, none of the words in post C.
Your Excellencies, however, the ambit of section 3BC is not merely limited to speech. It also extends to videos. These videos came in post B, and an ascertainment that Djibouti was involved in these videos came in post C, speaking to the fact that both of these clearly fall under section 3BC.
So we're looking here in terms of the necessity and the proportionality of the interference at the posting of a video under C.
Yes, Your Excellencies.
Nothing else, not the language of the post.
No, not the language of the post, Your Excellencies. The mere fact that she tried to associate Djibouti to the violence, and additionally, Your Excellencies, she claimed that NUP infiltrated the protest. NUP, Your Excellencies, was the leading party at that time. Djibouti was not involved in the leading party and was not a public official, which also shows, Your Excellencies, the very text of the post can also be considered to be false.
So, sorry, all of us are doing it.
Councillor, I wonder if you could address us on the question of whether the suspended prison sentence constituted an undue chilling of speech.
Just on that, to follow up, I think we've got to a position there that you are saying that this isn't an incitement for violence case, nor is it a glorification of terrorism case, but you're arguing that this is 3BC, so it's a misrepresentation of the truth case. Is it appropriate to extend someone a suspended prison sentence for that?
Your Excellencies, to answer both your questions in the order that they were asked.
Well, it's the same question, really.
To answer it together, Your Excellencies. In the present case, the suspended prison sentence has been imposed to ensure that Yara cannot simply evade the law by imposition of capital. Your Excellencies, Yara here is a millionaire. She has contracts worth millions of dollars on Azulfish, and a $50,000 fine, Your Excellencies, is unlikely to cause a chilling effect. The reason that the state has chosen a suspended sentence, that is, Yara is not required to go to jail as of date, Yara will only be required to go to jail if she recommits an offence of this nature.
So
Councillor, does it mean that wealthy people can only be sent to prison? They can never be imposed fines then?
Indeed not, Your Excellencies. That is not our submission. Our submission here is to say that there was a balancing that is required to be undertaken. Since Yara has the kind of command and influence that she does, the harms that were undertaken also have to be kept in mind. Because of Yara's posts, Your Excellencies, today, a private person has been physically stalked, threatened to the extent that he had to leave the country altogether. Your Excellencies, that has to speak to the fact that a suspended prison sentence of this nature was in fact required.
Well, let's look at it in a slightly different manner. I mean, this was highly political speech, wasn't it, in a highly political context. And how should we weigh that side of it? That one of the things we most definitely do not want to do in the jurisprudence under Article 10 and also the Human Rights Committee under Article 19 make it plain that the most important speech that we want to protect is political speech.
Indeed, Your Excellencies, we acknowledge that this was speech issued in public interest, but even then, Your Excellencies, from the case of Mekvikar versus the United Kingdom that was decided by the European Court of Human Rights in 2002, journalistic privilege in the context of freedom of expression must comply with the ethics of journalism, even if public interest is extremely high, Your Excellencies.
But this is one of the differences about Yara, is she is not actually purporting to be an independent journalist. She's an activist. We know she's an activist, a political activist in a movement which has a lot of followers. So is it correct to impose upon her the duties that are imposed upon journalists as opposed to somebody who is in fact a civic activist?
Your Excellencies, we differ on that account. If I may get you to page 7 of the competition case, paragraph 22. And Your Excellencies, reading with the quote, the second line, she is a former student of the National University and a self-proclaimed
Could I
journalist.
suggest you don't leave out the first line?
Your Excellencies, she is in fact an activist who is involved in the protest, but she proclaims herself to be a journalist. When you become a journalist, Your Excellencies, that comes with duties and responsibilities that must be adhered to. That duty here was due diligence, and it is our submission that Yara's conduct after Faces match clearly pointed out that there was falsity with respect to the videos, speaks to the fact that this due diligence was not undertaken and she acted recklessly.
But are all journalists subject to the same standards?
Indeed not, Your Excellencies. All journalists cannot be subjected to the same standard, and the means and the equipment available to every single journalist must be taken into consideration. That is precisely why we chose a case which laid the level of due diligence at the most minimum level of fact-checking, which Yara could have in fact undertaken even at the instance of the 2 hours that she had to make the post. If Your Excellencies have any further questions, if I'm of no further assistance, this marks the conclusion of my submission.
Thank you very much, Councillor.
Thank you.
Your Excellencies, if I may begin.
Yes, indeed, Council. Good morning.
Madam President, Your Excellencies, may it please the Honourable Court. As introduced by my co-counsel, my name is Gauri, and I will be extending the case on behalf of Respondent, the Republic of Boto, specifically pertaining to issue B on alleged violations about Azulfish's freedom of expression. Your Excellencies, the opposing counsel submitted that Azulfish did what any social media platform would do and not infringe the freedom of expression of others. However, Your Excellencies, it must be noted that Azulfish was not asked to generally suspend freedom of expression on his platform. It was merely asked to take action against content that could be reasonably interpreted as illegal content that existed on its platform. Your Excellencies, a balance must be struck here between the freedom of expression of the users as well as the other rights and reputations of people in general.
Counsel, sorry, can you just advise this court on where you see a difference between restricting freedom of expression and taking content down?
Your Excellencies, if I may clarify my position, while taking content down is certainly restricting the freedom of expression, it is not restricting legitimate exercise of the freedom of expression in the present case, since Yara's post that was asked to be taken down was in conformity with Article Section 3 of the DSL itself, which termed it illegal content.
May I suggest a kind of terminology here? There's a difference between an interference with a right and a legitimate interference with a right. And you're saying it wasn't interference, but it wasn't. It is legitimate as well. Is that what your argument is?
Your Excellencies,
Sorry, I mulled that question. I apologise. I'm making the distinction between an interference, which may or may not be legitimate, and then a legitimate or illegitimate interference.
Your Excellencies, in the present case, the interference was legitimate, and with this, I will be making 3 submissions addressing the submissions made by the opposing counsel. Firstly, that the restrictions were in fact provided by law. Second, they were necessary. And third, they were proportionate. Firstly, Your Excellencies, on provision by law, Azulfish was found to be in violation of Boto's Digital Safety Law, the DSL, specifically on provisions on provider liability. If I may bring you to page 5 of the competition case, specifically a continuation of paragraph 14.
So, just so that I'm clear, your co-counsel argued that we're looking at section 3BC for Yara, but are we looking also just at that for your client?
Your Excellencies, for our client, we see section 3BC read with section 11A.
Section 3 read with section 11?
Yes.
So it's a misrepresentation case, not an incitement case?
Yes, Your Excellencies.
So,
yes.
If I can, I'm slightly concerned about time and everything. I'm going to possibly, if it's with your permission, direct you to an argument which is possibly your weakest one about the divestment order. And you know this is coming. is it appropriate to make a divestment order which isn't anywhere in the DSL merely for apparently misrepresenting the truth?
Your Excellencies, allow me to address your concern in two parts. Firstly, the divestment order was not ordered at the first instance by the Court of Porto. There was preceding less restrictive mechanisms and restrictions that were imposed, extending from a suspension order, which was a civil interim measure, as well as a fine.
Proportionality point, but let's look at legality if we can.
Your Excellencies, while we do acknowledge that divestment in its very explicit terms has not been present within Section 12, if I may point you to Section 12b2, a permanent prohibition on operations within the national territory of the Republic of Porto may be ordered on a provider if they are found to be in violation of Sections 11a or b. In the present case, divestment, Your Excellencies, is a choice that has been given to Azulfish.
Really? It's a choice with a gun against its head, isn't it?
Your Excellencies, the choice
It's an order, unless there are judicial orders in this country, at least, which are called unless orders, unless you do this and that.
Your Excellencies, the choice that we refer to here extends to the application of the sanction under Section 12b2 or not.
Can we test this? Supposing the unless order was, and I'm using a silly example to make my point, so I'm not really making it sensible. The unless order was, unless you sack everyone with blue eyes in your company. Obviously, that's facially flawed. It's not in any law. So what are the limits on their ability to offer choices to the company?
Your Excellency, this actually brings me to my second point, that the divestment order was specifically instructed as an economic sanction upon Azulfish.
Okay, we're still looking at legality there, really. What's the argument that it's a legal thing?
Your Excellencies, when Azulfish decided to not comply with the DSL itself, it said that it earned $25 million in 5 minutes and therefore could afford to not comply with it. All sanctions within Section 12 exist in form of extended economic sanctions that may be imposed on a platform. The divestment, considering it is a subsidiary of all Azul, wholly owned by them, Your Excellencies, and taking capital for them, just remove the extent of capital that they could have used to be in non-compliance.
Well, can we just roll up the law on this, which I think I'm quoting from General Comment 34, paragraph 25. A law must be formulated with sufficient precision to enable an individual to regulate his or her conduct accordingly. Azulfish looks at Section 12. Do they know, can they foresee reasonably that they're going to be told to divest?
Your Excellencies, while I understand your concern, foreseeability with respect to sanctions does not extend to specifically knowing what sanction is going to be imposed on what action. This was given by the European Court of Human Rights in the case of Tolstoy versus the United Kingdom. In the present case as well, foreseeability to the extent that
Tolstoy was a fines case, wasn't it?
Yes, Your Excellencies, with respect to which sanction may be applied when on them.
But there wasn't a divestment order there. There wasn't anything related to the continual economic viability of a company.
Your Excellencies, allow me to take an example from the United Kingdom to address how this may not be entirely unforeseeable for any company. The United Kingdom, by their courts, recently ordered FTDI Holding Limited to divest 80.2% of their assets in FTDI themselves. This was for a possible intellectual property infringement of certain codes as well as technology for certain silicone chips. While intellectual property law, possible infractions of those do not provide for a divestment order that could be ordered, this was still taken into consideration because of the facts and circumstances of the case, Your Excellencies.
So that case is an interesting example, but what would you say the legitimate purpose, assuming you're correct for a moment, that 12b can be read to include a divestment order as a lesser form of the 12b permanent prohibition or a condition on it? What's the legitimate purpose served by the divestment order?
Your Excellencies, the purpose served by the divestment order is only to ensure compliance with domestic law as it stood by the day when Azulfish refused to comply with it.
But why would it make it any different who the ultimate shareholders are when in fact this is a company that is incorporated within Boto and therefore all the panoply of the law can be directed against that company? Is it going to be changed at all by the shareholding?
Your Excellencies, currently as Azulfish exists, it is with respect to its wholly owning parent company, which is All Azul. As was submitted by the applicants within their written submissions as well, financial ramifications of divestment orders may be seen within Azulfish as well. Considering that Azulfish throughout has been gaining their financial interest on a higher balance over complying with domestic law and court orders, we submit that the divestment order is merely to make them at a position where they do not hold this at such a high value, Your Excellencies, when they do not say that they can simply afford to not follow domestic law.
I mean, on the face of it, it looks like a kind of a nationalist project, doesn't it? And I don't understand why that's necessarily a legitimate purpose in order to give effect to a court order relating to regulating social media.
Your Excellencies, within the ambit of the ICCPR, when considering compliance with judicial decisions, this has been read into the legitimate aim of public order. Public order is extended to maintaining effective administration within a society and within the fundamental pillars that make up administration of a society. Considering the judicial system is part of this, General Comment 34, specifically paragraph 31, goes to say that laws such as those ensuring compliance with court orders fall within public order. This may even be seen in the European Convention of Human Rights in its maintaining the authority of the judiciary. This was interpreted by the case of Sunday Times versus United Kingdom by the European Court of Human Rights in 1979, specifically paragraph 59, when they said that ensuring compliance works towards maintaining the authority of the judiciary as well as the rights and interest of the litigants involved in a party.
Thank you, Counsel. I'm conscious we've taken you out of the line of your argument. Would you like to go back to it?
Your Excellency, circling back to the submissions with respect to an adequate notice, Section 11A refers to an adequate notice that must be supplied to a provider. Two objections were raised by the opposing counsel with respect to this. The first was who supplies this notice. Your Excellencies, in the present paradigm within Section 11A, an authority has not been nominated to provide this notice. This cannot be made to restrict itself to notices only by judicial orders.
Counsel, my understanding was that their point wasn't based on an interpretation of Section 11, but an interpretation of the norms of international law.
Your Excellencies, to address that as well, multiple jurisdictions employ private party notices. For instance, South Africa in Section 77 of their Electronics Communications and Transactions Act, the European Union in Article 16 of their Digital Services Act, India in its Section 16 of its Intermediary Guidelines 2021, as well as Australia in its Section 50 of its Online Safety Act. All of this and much more work towards allowing private notices. This is for two reasons, Your Excellencies. First is accessibility. If every person who has any concerns with respect to certain posts is expected to go before a court, pay their fees, take the time that it takes, Your Excellencies, to get that court order and only then get the post removed, it will lead to an elongation of the time that could be taken in getting these posts down. Even in the present case, the posts were made on 1st April. The Central Criminal Court's order came in August 2024, Your Excellencies. The time difference is simply too much.
And Counsel, just on that point, so just so that I'm clear, there are two parts to Section 11, the failing to comply with the adequate notice, and then there's actively promote. Are you arguing that the leaving the content up amounted to active promotion?
No, Your Excellencies, it amounted to omission after being provided with adequate notice.
Thank you.
If I may point you to page 10 of the competition case to demonstrate how adequate notice was provided, starting from paragraph 38. Your Excellencies, paragraph 38 also recognizes one of the claims made by the opposing counsel that no user reporting mechanism was used. However, Faces Match was a user on Azulfish, which was seen by their posting on the platform, and they submitted an official request to delete post C since it was digitally generated by AI and spreading fake information. Your Excellencies, it must be considered that Faces Match was the very platform that Yara claimed to use when making her post. The very platform, Your Excellencies, disavowed the post as being a correct valuation of events. They refused to comply with this. Faces Match then approached the judge of first instance and received a civil interim measure in their favor, Your Excellencies. The civil interim measure explicitly
Sorry,
characterized...
Counsel, just to follow on this, it appears that the reason that Azulfish gave for the request to take down the post was to protect the company's reputation. Is that an adequate reason to suppress speech that is possible in the public interest?
Your Excellencies, while I understand your concern, the official request contained the information that was necessary for making Azulfish aware about the existence of illegal content on his platform. As per Section 11 Clause A, as it stands, the notice only needs to be about the existence of content which can be reasonably interpreted as constituting illegal content. And therefore, even with this notice, that would have been sufficient to make that reasonable interpretation on behalf of Azulfish.
So your argument is that it's an expectation from private intermediaries that they do make determinations as to whether content that it's characterized as breaching certain interests also falls under other categories of the law. Isn't that too big an ask for a private company?
Your Excellencies, if I may differ on that account by giving an example of the notices that would or would not be adequate notice. If Faces Match had simply said, Azulfish, please delete post C, it is harming my reputation, that would not have been sufficient notice because that does not provide for any of the prongs within Section 3B. However, in the present case, the notice went to say that this was AI generated, constituting false avocation of the events that took place on 1st April, and therefore provided enough information for a reasonable interpretation to be made on behalf of Azulfish. In any case, coming to paragraph 38, Your Excellencies, the judge of first instance in very clear terms considered post C to be digitally fabricated and constituting disinformation. Your Excellencies, seeing as how Section 3BC is a disinformation law, it must be seen that Azulfish could have seen that this was reasonably interpreted to be legal content. Addressing specific contentions raised by the opposing counsel with respect to the judge of first instance, Your Excellencies, firstly, on their use of Faces Match. Your Excellencies, while they submit that Faces Match had 99.9% accuracy, and since post C had Faces Match screenshot, Azulfish did not need to do anything. This must be seen in light of the context that in a very previous paragraph, Faces Match themselves said that this was not true. Further, Your Excellencies, they said that there had to be conclusive determination of the post as illegal content for this to be a valid notice. However, the standard that is employed within Section 11A is of reasonable interpretation and not conclusive determination. If conclusive determination is read into Section 11A, Your Excellencies, it will merely mean that a person will have to go to court, get that order, and then go with the notice to the provider. Thirdly, Your Excellencies, they submitted that it was reasonable for Azulfish to not comply with the judge of first instance's order. Your Excellencies, if private parties are simply allowed to make value judgments on behalf of what should be law, what should not be law, and therefore they can choose which law to follow and which law to not follow within a domestic system, Your Excellencies, this sets a dangerous precedent on what private parties could do. Upon reasonable interpretation specifically, Your Excellencies, the information that Azulfish had was, first, Faces Match, the software that Yara had used, said this was false. A judge of first instance said it was disinformation. Faces Match's software engineers said that the videos were altered, Your Excellencies, and could not be considered an accurate interpretation of events of 1st April. All of these collectively were in fact sufficient for ensuring the reasonable interpretation of there being illegal content. Your Excellencies, addressing with respect to necessity of enhancement of the punishment to a conditional prohibition on operations.
Just before we get there, if we can, so just thinking about the possible arguments that could be advanced by Azulfish in relation to defying the order. The posts have been viewed a million times, and there have been 200,000 shares. I think the population of the country is can anyone remember what the population of the country is? I think it's 10 million, so was it 20 million?
100 million, Your Excellency.
How many?
100.
100 million. Okay, so it's got 100 million and it's been viewed by a million people, 200,000. And by the time all of this court process happened, it's actually 3 or 4 or 5 days ago. The cat's out of the bag, isn't it? What's the point of taking down the posts?
Your Excellencies, allow me to address your concern in 2 parts. Firstly, mere lapse of time cannot be considered a valid justification for not complying with the law.
Okay, let me turn it this way round. So the legitimate aim is promotion of the rights of others or promotion of public order. How can taking down posts when the information has gone out there, how can that be rationally connected with the legitimate aim of protecting the rights of others?
Your Excellencies, the posts that were posted by Yara on Azulfish have been live for 9 months and over that, Your Excellencies. The extension and their staying on that platform only serves to give them legitimacy.
All the damage has been done.
Your Excellencies, rights and reputations do maintain to be a continuing damage that was faced by Djibouti. At present, he's still not in the country that he was
Sorry,
born
Counsel,
in.
just for the sake of consistency, you say this is a disinformation case. It's not based on protecting the rights of the others. So do we take an issue here with Djibouti's reputation or we don't?
Your Excellencies, the restriction works towards protecting the rights and reputations of Djibouti as well as maintaining compliance with the domestic law itself. If we consider Section 3BC, when it talks about misrepresenting the identity of the people conducted within perpetrators of violence and the conduct of violence.
If it's individual rights we are concerned with, do we know whether Djibouti actioned this right? Did Djibouti take action to protect these rights? Did, for instance, file a lawsuit, defamation lawsuit? And if he didn't, it is for state authorities to substitute themselves to the determination of an individual who may want to decide whether to activate the rights or not.
Your Excellencies, while Djibouti has not filed any legal action against these posts, it must also be considered that he is not within Boto currently. He is in Launchland because he was ran out of his country because of these posts. Further, Your Excellencies, the rights and reputations of Djibouti form a legitimate aim for the specific restrictions that have been imposed. As per General Comment 34, paragraph 25 itself, it is allowed to make determinations on specific restrictions and their legitimate aim. In the present case, since it corresponds to the rights and reputations of Djibouti, that is also taken as an aim of imposing the restrictions. Your Excellencies, briefly addressing the proportionality of the responses taken by the state of Boto. Firstly, that these restrictions formed as a graduated response. A graduated response is allowed because it is the
Counsel,
least...
you have 3 minutes, so I'm going to bounce you if I may.
1 minute.
1 minute, you have. I'm going to bounce you. So graduated responses, let's look at what they did. They fined $25 million, $25 million, and then there was a divestment order and possibly a permanent ban. There was one thing they could have done, which still was at least lesser restrictive means than the divestment order. Section 12B, they could have fined 3% of the provider's previous annual turnover, which I understand, I'm reliably informed by somebody else, is 7.88 billion. They didn't do that. There was at least lesser restrictive means available.
Your Excellencies, we submit that increasing the fine would have been immaterial in ensuring compliance since Azulfish, if I may point you to paragraph 43, has an attitude towards fine that they simply do not affect them because they stand to promote an unrestricted freedom of expression.
Well, 25 million didn't concentrate their mind, but 7.88 billion might have done.
Your Excellencies, could I seek an extension to
You may
address?
ask the question.
Your Excellencies, to address your concern also with respect to the fine that has been imposed, the state of Boto imposed fines on 2 instances, which were $25 million and $50 million. The next sanction it imposed on divestment was on an economic sanction of a higher level as well. In this case, if it had restricted itself to just increasing fines by $25 million, Your Excellencies, this would have led to the post being up for much longer than it had to be. Seeing as how their response to this is simply, we have enough money and therefore we do not have to comply with law, extending fine perhaps in its mere terms would not have led to ensuring compliance. As per the European Court of Human Rights' case of Funky versus France, to ensure compliance, a higher restrictive measure could be given. Your Excellencies, if that addresses your concerns and if there are no further questions, this marks the conclusion of my submissions.
Thank you, Counsel. Yes, Counsel, when you're ready.
Madam President, Your Excellencies, 3 points in rebuttal. Our first point of rebuttal goes towards the basis of Yara's prosecution. In response to Your Excellency's question, on which subsection of Section 3 Yara was charged under, the first agent for the respondent argued that this is a case of misrepresentation and that Yara's posts were false. This means, Your Excellencies, that their case stands and falls on proving that the videos were digitally altered and that Yara's posts were false. But Your Excellencies will find that the first agent for the respondent will not be able to point to a single objective fact in the compromise that shows that Yara's posts were false or that the videos were digitally altered. Second point, Your Excellencies, on the journalistic duties of Yara. In response to Your Excellencies' question on what the state expects Yara to do, the first agent for the respondent argued that Yara should have interviewed the eyewitnesses, asked the police officers what had happened, or even asked the severely injured policeman in the hospital who exactly had attacked him. But Your Excellencies will again find that the respondents cannot point to a single authority that shows journalists are expected to take that kind of obligation. Instead, we offer this court a host of authorities that shows journalists are only expected to act in good faith, with reasonable belief of their statements, and to make statements with sufficient factual basis. These cases are the 2015 European Court of Human Rights decision of Balakas and Greece, the 2016 decision of Magyar and Hungary, and the 2024 decision of Oleg Balan and Moldova. Our last point of rebuttal, Your Excellencies, goes towards the condition to divest. In response to Judge Danbury's question on whether this divestment is provided for by law, the second agent for the respondent explained the rationale for why this divestment condition was imposed. But Your Excellencies, this is a fundamental misunderstanding of how the provision by law limb works. The provision by law limb states that the punishment must be found within the letter of the law. And this was stated by the 2021 African Committee of Human and People's Rights decision of Agnes and Rwanda, the 2021 European Court of Human Rights decision of Akandis and Turkey, as well as the 2020 decision of Flavus and Russia. Your Excellencies will again find that the agent for the respondent cannot point to a single authority to show that PBL can be satisfied by explaining the rationale of an onerous sanction. Your Excellencies, this concludes the case for the applicants. I thank this court for its time.
Thank you very much, Counsel.
Thank you.
Your Excellencies, may I begin?
Please
Your
proceed
Excellency,
when
it's the same 3 points on rebuttal. First, on the basis of Yara's prosecution, the opposing counsel contended that there is not a single objective fact available on the record to show that these posts were conclusively false. Your Excellencies, we acknowledge that expert opinion was divided and unclear, but this division was limited to the investigation stage. Immediately after the investigation stage, a criminal court, Your Excellencies, Boto Central Criminal Court, where the standard of proof is likely to be one of beyond reasonable doubt, and thereafter the Supreme Court of Boto have conclusively found this content to be illegal content, which speaks to the fact, Your Excellencies, that since this prosecution was based on the fact that Yara's posts were digitally altered, this was false content and proven to be so before the domestic courts. The opposing counsel, Your Excellencies, have not been able to show any doubt with respect to this conviction. Second, Your Excellencies, on the question of journalistic privilege, that is, the level of due diligence that was cited by us was something that could not be attained by Yara. However, Your Excellencies, journalistic privilege is conditional. It depends on good faith and a reasonable belief in the truth of the information disseminated. In the present case, Your Excellencies, Yara's post-publication conduct speaks to the fact that there was no good faith on her part. Clearly, after Faces Match pointed out that these videos cannot be relied upon, the least Yara could have done is issued a clarification or issued a rider appended to her posts that these videos cannot be relied upon. Yara chose not to do that. Yara kept silent. This shows, Your Excellencies, that Yara preferred to spread her political narrative as opposed to spreading reliable information. On the third point of rebuttal, Your Excellencies, whether the condition to divest is not contained within the law. Your Excellencies, we recognize that an explicit mention of this condition is not within the law. However, the very principled punishment, that is, the condition is given on a principled punishment contained within Section 12b(2). A permanent prohibition is contained within the law. The condition has been added simply because Azulfish's constant attitude towards the prosecution was that it can defy the law because it has capital. Your Excellencies, after a provider says that they earn 25 million in 5 minutes and they have no intentions to comply with the domestic law of Boto, the only choice, Your Excellencies, that was left with the state party was to impose a condition of this nature. In fact, Your Excellencies, this was a lesser intrusive measure that was available within the law, which speaks to the fact that the state of Boto prioritized the freedom of expression. Thank you, Your Excellencies. If I'm of no further assistance to this court.
Thank you, Counsel. The court is indebted to counsel for their very able and clear arguments. We are now going to adjourn to deliberate on our decision, and we will rejoin you later.